Okay, now we move to the judicial misuse of political repression with Dr. Jaime Vintimilla. He's Professor Vintimilla is a faculty member of San Francisco University Law School and a professor at the graduate program in law at the Andean Simon Bolivar University in Quito and Alcalá de Henares in Spain. He has written more than 25 articles and books about constitutional and financial law, also about arbitration, mediation, history, genealogy, and the Indian justice. Let's welcome Professor Vintimilla.
To everybody, it's really a privilege to be here, and unfortunately I have just a short time to express some ideas about the case that I had to draft. Well, the title is Terrorism Forged in a Constitutional State of Law, because in Ecuador, I think I forgot something very important. Maybe because I'm thinking right now in English. I have to thank first. But I have to thank, the IID for the great possibility to speak about the weakness of the judiciary, the Ecuadorian judiciary, that in my opinion right now is destroying the rule of law. Or maybe I have a question. Maybe it's reframing it. And take it the substantive used by the Professor Cassell. We have 5 caveats in Ecuador, at least. My first caveat. I think we have a new concept, a new definition of coup d'etat. Because right now, it's not perpetrated by military forces. I guess it's perpetrated by lawyers. Because if you compare Venezuela, Nicaragua, Ecuador, and other similar countries, they all start with a constituent process in order to draft a new constitution, and all the people vote for them, and they are happy. They all live in a paradise, a legal paradise. And they have new rules, but they have to face ancient mistakes, all mistakes. And I think that's my first caveat. My second caveat, the judges are selected by merits. At least it is what they say. It's written in the rules. But if you see the conditions, the requirements to be a candidate, you will find a link strongly, connected with the power. Advisors of the president, ministers, and they do whatever they do. They have all the power to do everything. Because in 1 year they are ministers or something, and the next year they will change, and they will be whatever. No problem. They are, capable for everything. My third caveat has to do with 2 types of judicial cases that must be faced in Ecuador. And this morning we were talking with Daniela. I think the first one has to do with the common people. Have to be with property, has to be with just private interests. But we have a second sort of cases in which the interest is of the power. We have a government interest in which the judicial methods and techniques, of course, will change. My fourth caveat has to do with the necessary definition or redefinition of what really means a good and effective democracy. Because I think democracy is very important. It's even a right. But in countries like Ecuador, where we have poverty, that we have corruption, must be linked to the necessity to cover that people need to eat, that people need to go to school, and that the authoritarians use it for a new way to get the power and emphasize these people. So, my caveat is, how will link principles, institutions, with the main problems that people must face every day? And my last caveat is about the Constitution. it's really a legal frame to face and control the power, or it's just a structure to facilitate the power of the person. L'État c'est moi, it's the rule to govern, not 2 centuries ago, but today. So I think we are living a sort of backlash to the absence of law. I guess that's the regional problem that we have to face, that we have to study, that we have to understand, and not just at school, but in the cultural level. We need to understand what is going on this. Going to the case, I think the case is just one more of the cases within a path that is full of lack of independence, especially in those procedures, as I said before, that have to do with political interests of the government. This case will enter into judicial history like the trial of the worst and darkest episode of the Ecuadorian judiciary, since innocent people were condemned according to pressure coming from the government servants. Without any doubt, the case will be remembered as one of the signs of the great failure of the judicial system. At least that is my conviction. But what we have to see in a short period of time, what we can see about this, how we describe this case, that, by the way, Professor, he made a great job, doing a brief description of every case. The purpose, I think, why I dare to write something about this case, because I tried, at least the case seeks to show the serious violations of human rights that occur during the conduct of proceedings before different courts, being the most relevant the abuse of various precautionary measures, cautelar measures, as well the transgression of the principle of criminal doctrine of consistency through a distorted and even fanciful interpretation and application of any principles of Ecuadorian law, really universal law, but one is jura nobis curia, principle that which lead us down to the dark of criminal law of the enemy. And I think that's very important, because the penal principles, the penal law, is using not just to criminalize, is used like, I would dare to say, not just ideology, but a program to control the citizen that are against the government. Tries to discipline the citizens that are against the government, or just they are thinking in a diverse way. About the key facts and issues, I just want to say very concrete. I want to just be concrete. And what happened? Okay. On November 2011, I just translated like that, bombas pamfletarias, using like pamphlet bombs, but I don't know if it's the same sense, but I decided just to describe like that. 3 pamphlet bombs exploded in Quito, Guayaquil, and Cuenca. These detonations were related to the group of popular fighters of popular combatants. On March the 3rd, 2012, the police operation called Red Sun, really was Pucainti in Quechua, began with the raid of an apartment located in Luluncoto, which is a southern neighborhood located in Quito. Since they proceeded to arrest 10 young people who were just meeting, trying to decide their participation in the march announced by the indigenous movement in defense of water, dignity, and life against mining, which should arrive in Quito on March 22nd of 2012. Besides, all the accused were students by the time or young professionals who have completed their study, their careers in state universities, and have also had some experience of leadership. According to one testimony of them, the date of the arrest, they met only to study the Constitution, they said, as well to discuss diverse problems of the country. This reality leads us to the inevitably two readings of the meaning. One comes from the people themselves, gather and accuse, while the other comes from the police, interior ministry, and judicial servants of officials. The problem is that the second version was the unique used by the judicial system. And that is terrible because the prosecutor and the judges found a crime where just was not possible to find evidence. You know what the police found? $20, just books, photographs of Che Guevara, something without importance. I don't know if I have a book just about philosophy. I'm going to be a philosopher. I will bet I would love to be treated like that. But that was really the situation. Just a last point about the key issues. Was very tough, the behavior of the police, because two specialized groups met into the apartment where people, they just get in, and were members of the intervention and rescue group and unit for combating organized crime. They raided the place and they, got into the jail to the people. This is terrible because the prosecutor launched an investigation just based on this evidence that I said before. And that, I think, is terrible. That's again the provisions of the Constitution. And in my opinion, as of the many people, this invalidates the arrest, the search, and the seizure of property members of the group. Something that is terrible also is the time that takes the procedure, 4 years. And even with a new constitution and with a new penal law in which the penal type disappeared, the National Code took 2 years in order to understand that they have the possibility to say that these people is innocent. Something very, very strange. In order of time, the legal reasoning. I think within the present case, the judge and the prosecutor forget any form of legal reasoning, since they don't use neither deductive reasoning nor linear reasoning, and it is not capable to use analogy. Unfortunately, the judicial servant just use the arbitrariness as a background of their decisions, reckoning on the pressures of executive branch. I think if you don't see the case like that, it is not comprehensible the violation of many rights, due process, special procedural defense, presumption of innocence, physical and psychological integrity, privacy, reputation, etc. So you will find, I don't know if I have more time. I'm on time.
2 minutes.
Okay, so I will finish then. What human rights have been violated in this arbitrary procedure and why? Well, at least 10 rights that are within the Constitution. A lot rights that are in the Universal Declaration of Human Rights, as well as in American Declaration of Human Rights. But above all, in Constitution, the right to due process of law, and in particular, the presumption of innocence, evidence duly and legally acted, the right of persons to defense, especially the guarantees prohibition of deprivation of the right of defense, have the time and the means to proper defense, be heard in the timely and equal, present evidence and contradict those filed against verbal or written, etc., etc. Just to finish, I would like to express conclusions. This case allows us to see a clear imbalance between the different branches of government and the lack of both internal as external judicial independence. Why? Because government needs to create a ghost. What is the ghost? That we don't have security. And what's the best way to cover the security? Finding innocent people and call them terrorists. On the absence of external independence, a strong influence and interference from the executive branch to the various institutions involved in the administration of justice is undoubtedly observed. Pressure exerted through a kind of superior hero figure, since the case is seen as a media game, as well as the generation of a specific enemy that must be fought with enemies for the benefit of national security. Relying on distorted interpretations and on the basis of the above premises described, a violation of several fundamental rights, where due process is the most unnoticed, shows the return to the top of the authoritarianist expression, l'état c'est moi, and the state. Thank you very much.